Alan Schnorman. Mr. Schnorman is a distinguished trial attorney, author, and lecturer. Each week, Lawline will bring you the most knowledgeable experts in the field of law today. And now, we introduce our guests and our host, Alan Schnorman.
Welcome to Lawline. What is the responsibility of a reporter and the newspaper he works for to make sure the facts of a story are accurate and true? When does a story cross the line and become libelous? Today we'll look at this issue with noted First Amendment attorney Martin Garbus and with a reporter from the New York Law Journal, Ed Adams. Hello, Marty. Hello, Ed.
Hi.
All right, Marty, tell us, you're involved in this major lawsuit now. Tell us about it.
Well, sometime last April, a woman was running through the park.
Prospect Park.
And she got raped. And that evening, she went to the hospital, and the hospital records confirmed that she's raped. The following day, journalist Michael McAlery writes an article
For the Daily
News, saying that the woman didn't get raped, that it's a hoax, that it's a lie. Then the police commissioner, realizing that McAlery may have relied on some information at a confidential press briefing, goes public, and he says, we have physical evidence that the woman was raped. The following day, McAlery writes another article. Then there's a lab report.
What did the second article say?
29, saying basically the same thing. The woman is lying. The physical
Even
evidence
after he had the information from the government?
Yes, from the government and from the hospital records and from the lab report. Then on April 29th, he writes another article saying the same thing. Then everything is quiet for a while, and then on May 13th, he writes still a third article. By the time he writes the third article on May 13th, there's a lab report, a hospital record, and you have the police statements. You had a number of police out there conducting an investigation, and they had all concluded at that time that she had been raped. Now, what also happened in this period of time, 25 journalists from the Daily News signed a petition to their management saying, we have seen the articles of McAlery, they are inaccurate, that there is no evidence to justify the charges that he has made, and they asked the Daily News to apologize to the woman and to make some kind of statement. The Daily News management refuses to do it.
Their editorial board, I assume?
The editorial board refused to do it. In fact, they said that McAlery has a history of authoritative reporting, and they see no reason to say anything further about that. I have never represented a plaintiff in a libel suit. I represent the media. I represent
newspapers,
magazines, book companies. If I had seen only the first article, which was wrong, I could excuse that, perhaps, on the grounds that he didn't have time to check out the story, that he was trying to run out with the story. If I had seen the second article, I might even have made the same defense of him. But May 13th, which is 2.5 weeks after it happens, by then, he knows that every other newspaper, every other television program has said that there's physical evidence of rape. No one, there are dozens of journalists around, no one writes that they report the story. One other thing, the newspapers, other papers covering it, the Daily News itself, the Post, and the Times, give the names of police who are involved in the investigation. He doesn't call any of the police who say that they have confirmed the physical evidence of the rape. He does not do any check into the woman's background. He does not contact her employer to learn anything about her. But he creates in these articles a fictitious person who is fundamentally, according to him, a liar. And he calls her Tawana Brawley and other images which conjure up a rape and a hoax.
Well,
that's the case.
Didn't he also indicate that she was a lesbian spokesperson
yes,
in the community?
Yes, he also said that the reason she did this, or the reason she hustled the rape, is there was going to be a rally that Saturday, and that she had planned to speak at the rally, and then in one of the articles he said she did speak at the rally. She didn't speak at the rally, she didn't plan to speak at the rally.
Was he trying to intimate that the reason for this event was to bolster her position at the rally?
Yes.
And the event never happened, just for her to add credence to her position at this rally that was going to be forthcoming?
Yes.
Okay.
I'm curious, though, about something, if I can just interject here. In the very first story he wrote, what sources did he use to support the proposition that this was a hoax?
You answered my question, my next question, okay.
He's refused to state who his sources are.
But I'm just saying, in the article, what did he say? According to sources? According to police?
He says according to police.
According to
and then the police, Bratton then conducts an investigation. And according to the police investigation, none of the reporters spoke to him. None of the cops at the scene spoke to him. McAlery has never said that he spoke to anybody who actually spoke to the woman. So what he does,
would he have necessarily had to speak to anybody who spoke to the woman?
It depends how you define a source, and that becomes a legal issue.
And let me ask you this: you know, in the movies, when I watch the cases of libel,
Right.
I always see them say they get one source and they have to confirm it with another source, or at least to their editors. They have to bring a package to their editors and say, "This is how I got my information from this source, and it was confirmed by this source." Is that what really happens?
Well, I think generally reporters, if they're dealing with something sensitive, have to tell their editors where they're getting their information from. You don't just walk into an editor and say, "I've got this story," and they run it with no questions asked.
Because there's exposure.
Because there's exposure.
Money exposure.
Now, you got to remember that when we're talking about the McAlery case, McAlery isn't exactly a reporter, a working reporter like me and plenty of other people in New York. McAlery is a columnist. And as a columnist in a city tabloid, you do more than just report, although that's part of your job. You also bring an attitude, a point of view to a story. And that's something that I think McAlery has said publicly on many occasions he tries to do. That's what makes a columnist more interesting to read than a reporter like me, who just covers the facts in a fairly straight-ahead fashion. There's some viewpoint and some opinion in his columns, and that's quite clear when you read them.
But from your point of view as a reporter, is there a different editorial position as to what a reporter can bring to the newspaper and have published, or a person who writes a column can bring to the newspaper and get published?
Yes and no. No in this sense, that the facts in a column by McAlery or any other city columnist have to be facts. They're supposed to be true. Sometimes reporters make mistakes. Sometimes those mistakes are so great they're libelous. I don't know whether that's the case here.
I'm the editor. Do I have an obligation to say, "Hey, McAlery, tell me how you got this information before I send it out to hundreds of thousands of people? Tell me how you got it"?
Probably, I think that a responsible editor would do that, unless they have a relationship with McAlery dating back probably several years, in which they have an understanding that his sources are so impeccable and so on the money all the time that they can trust McAlery without asking that question.
On the contrary, in this case, with respect to McAlery, he has a history of writing inaccurate articles, and he testified in a deposition that he doesn't know the difference between perjury and fact, that he uses literary license, and he has a whole series of articles. For example, there's one about a grand jury, a cop going down before a grand jury, where he writes in this article, a cop goes down before the grand jury is asking him a certain question, the cop responds in a certain way, and the grand jury decides it never happened. It never happened. And what happens is that he's a reporter who now has a history of this. The Daily News knew this history. He testified in a case involving Zuckerman when he was jumping to a different newspaper. Now, what you said and what Ed said, I think, is very interesting. Does an editor have an obligation to ask those questions? And what Ed said, yes, if you're writing facts, basically. The Daily News never did that.
How do you know that?
We know they never did.
Did you take the deposition?
We know that. We haven't taken the depositions. They've opposed the taking of any depositions, but I know it. In other words, I know what happened. I have it from...
Are you saying
And
that
what's your source on that? I mean, as long as we're talking about giving sources, what's your source on the information that they never did make that inquiry?
I know that. We're not talking about giving sources, because McAlery is not giving sources.
But you're not going to tell us what your source is for that
I will
piece of
tell you
information.
that... Oh, no. Let's go ahead.
Martin, are you entitled,
Go ahead.
as a plaintiff in a lawsuit, to know where the reporter got these, quote, confidential sources?
Well, basically, a journalist has a right to protect his sources. It's something called the shield law. So he has a right, and I think it was very interesting in this case. There's a journalist named Myron Farber, who's a very respected journalist. He himself had been jailed for refusing to give up his sources, and he wrote an article on this for Vanity Fair.
He was held in contempt, if I recall.
He was held in contempt. He did some time in jail. And he's a wonderful, wonderful
A
journalist.
long time in jail. He stayed day by day. The judge kept him in jail and brought him back continuously and kept asking him, and he kept refusing.
Right. So when Vanity Fair asked Myron Farber to do an article on this, I had a feeling that he's a journalist, that he would have a bias towards someone who protects his sources. Myron Farber, and you'd have to read the article, his conclusion is very clear about what happened in this case and who's right and wrong. In a libel case, he has an absolute right to protect his sources without going to jail. So McAlery doesn't have to say anything. I mean, you're a sophisticated lawyer, but you then basically have the hearsay rule, namely, if McAlery gets up and he says, a guy told me, and you can't find out whether that's true or not. In other words, McAlery can't get on the stand and make up something and say, a guy told me this or a guy told me that. He has to give a source for a particular story.
Right.
So what the judge has held is if McAlery wants to rely on any information, then he has to disclose who it came from. He already indicated he had conversations with one guy, a guy named John Miller, who was then with the police. And Miller has fundamentally contradicted McAlery.
All right, let me ask you this. A source gives you the information. A source gives, allegedly, McAlery this information that this woman is a liar.
Right.
A liar to the public. Right. And actually, he's not only saying she's a liar, she committed a crime because giving a statement of this nature to the police, a false statement of reporting a false incident, is a crime.
It's a crime. It means that she would have committed a crime. She would have started the whole criminal process. People are being dragged in.
Now, you're saying he doesn't have to give up the person, the source or sources of the person or persons who told him this. Does he have to prove whether or not it's true or not in a libel
Well, he
suit?
doesn't have to prove. The fact that he doesn't have to prove that he doesn't give up the name of sources doesn't mean, I mean, he can't do it, but it doesn't mean that he can't come in and say, hey, she wasn't raped, because here are these 7 other people. So he can prove the defense, even though he protects the source.
In other words, he can prove...
He's not limited in any way.
What does
he can prove 2 things. One, he can try and prove. He can't prove it. He can try and prove truth.
Because he has another point of view.
He can try and prove that the rape never occurred.
That she's lying.
That she's lying. My judgment is that that's the defense they originally took. That defense, I think, is so nonsensical that they're going to go to defense number 2, and the defense will be that they relied on reliable information.
That was my
So they're
question.
2 separate
if they're
defenses.
relying, how do they prove that without giving up their sources? Who are these mystical people in this smoke-filled room giving all this information to you if you don't know who these people
Well,
are?
to some extent, if he produces 10 people, and if these 10 people, all of whom he says are not my sources, basically say what the sources said in the newspaper, then that's how you defend the case. I mean, you can't do it, and I don't want to get into, kind of sophistry, but that's how you defend the case.
From a reporter's point of view, how do you feel about this?
Well, I mean, I feel a little uncomfortable being in the same profession with Mike McAlery. I mean, he's a guy who has a reputation, I think, among people who follow media in the city, as being, particularly in print, not necessarily in person, a bully. I mean,
He must be
he's a
extremely
guy,
popular if he's with the Daily News, which is our major
to my way of thinking, inexplicably. I mean, as Marty alluded to, there has been bidding wars over this guy's services. I mean, in my opinion solely, I think the guy's essentially a knockoff of Jimmy Breslin.
You're giving him too much credit. He's not even that good.
Well, you know,
I didn't think that was so bad, being a knockoff of Jimmy Breslin.
Go ahead.
But I mean, it seems to me that one of the problems in this case doesn't have to do with McAlery. It has to do with the person who's bringing the suit, with Marty's client. And one of the things that's happened in this case is the courts have found that this woman is what's called a public figure, which means she's not your average person. She's somebody who is more well-known than your average person. For libel purposes, that has a variety of different implications that he can talk about. But basically, they're saying she's somebody who's well-known.
Because she was an activist in the lesbian community?
In large degree, yes.
Okay.
Also, the courts have said, we're not going to disclose her name.
Does that put her on the same level as a politician? As a
Essentially,
mayor?
I think
or?
that's correct.
No, I think we can talk about it further.
But I mean, it's the same category.
Okay.
It's roughly the same category as somebody who is widely known. But the courts have also said that this woman, because she is a rape victim, will not have her name disclosed in the course of this case. I believe the case is captioned Jane Doe, is it not? Which, to me, seems to be a hypocritical position. On the one hand, she's widely known. On the other hand, we're not going to tell anybody what her name is.
Well, her name was already reported in the newspapers. I mean, I saw her on TV.
No, you didn't.
I didn't? I saw something on TV.
What Ed is saying is right, without getting into the detail too much. Namely, if you're Jane Doe, If I'm Jane or Jim Doe, then I'm not Martin Garbus. I mean, it's one or the other. Either you're a public figure or a private figure. I think that what happened is that, and by the way, that's being re-argued, and my judgment is that the judge will change his opinion, and she will be considered a private figure.
Are you taking that up on appeal, or are you doing it in the...
No, we're doing it before him. And I think that, I think that the basic issue, namely, and let's talk about this case for a second, because I think that I have been a defender of the First Amendment. I think journalists can make mistakes. I think people working under deadlines can make mistakes. And I think that there's something in the First Amendment called breathing room, which means you have to tolerate, you have to give some tolerance to journalists like Ed who work under pressures. You and I make mistakes, we're lawyers, journalists make mistakes. Nobody gets shot or should be sued like that just because they made a mistake. Here you have 3 articles, April 28th, April 29th, and then May 13th. Here you had a petition from 25 writers at the Daily News prior to the 3rd article, asking the Daily News management to walk away. The reason they didn't walk away is because of what you two were talking about before, namely, he's a journalist who sells. He sells the Daily News. So the responsibility at some level here is not McAlery's, who I think is a wild cannon. The responsibility is the management of the Daily News.
Is it your position they acted with like a depraved indifference or a recklessness in publishing the later articles?
Well, the law would say, we call it malice. The law would call it recklessness. That by the time you write the 3rd article, May 13th, every journalist, no other journalist in New York has questioned this. You have hospital records, you have medical records. He's the only guy beating this drum.
We'll continue this right after the break. You're watching Lawline. Stay with us.
In a life-threatening emergency, you should know what to do. Say a loved one exhibits unusual symptoms. The first thing to do is... Clear! No. The first thing to do... Oh! Tourniquet! No! The first thing you do is pick up the phone and dial your emergency number.
Call 911 first.
Right.
How about mouth-to-mouth?
I don't think so. To learn more about life-saving techniques, contact your Red Cross.
Your approach is looking to cover.
The men and women in the National Guard and Reserve face some tough challenges when they serve. Challenges that teach them discipline, leadership, and technical skills that make them better employees. So when they need time off to serve, don't make their toughest challenge approaching you.
It's only a little motor oil.
What difference is one drop of paint gonna make?
This much fertilizer isn't gonna pollute anything.
You're looking at a sea of excuses, created drop by people like you and me. Our waters can be saved if each of us does their part. Drop by drop. If we all do a little, we can do a lot. Brought to you by the Natural Resources Defense Council, the EPA, and the Ad Councils of the U.S. and Japan.
Hello, you're watching Lawline. Today's topic, we're talking about the First Amendment right. The right of a reporter to write an article which another attorney says that is libelous. We're now with Martin Garbus, First Amendment attorney and an expert in the field, and a reporter, Ed Adams, for the New York Law Journal, and we're discussing this issues. Ed, let me ask you this. You write for the Law Journal. Sometimes you write articles regarding attorneys and stuff of that nature. What I'm really interested in, when a reporter goes to journalism school, what do they tell them? What ethics are involved before you go out and write an article that could very well put someone in a terrible light, or actually in this case is accusing them of a crime?
Well, I mean, I think obviously your first duty is to write an article that's truthful. And if you write an article that's truthful, truth is what's called an ultimate defense to libel.
So no matter what I say, if it's true, I can say it.
No matter what I say.
I can call you unchaste and it's okay.
Exactly. And there are a variety of other ways that you can write about things and not have to worry at all about libel. For instance, there are some people whose reputations are so bad, they can't be libeled. An example, sort of classic example of this is Lee Harvey Oswald in the days after Kennedy's assassination. You couldn't say anything about Lee Harvey Oswald that was worse than had already been said. So you were on fine ground saying anything you wanted to.
Somebody's been convicted of being a mafia leader. Can you say anything you want about him?
Pretty much.
Okay.
I mean, it would depend on the facts and circumstances, but essentially. Another approach is if somebody's dead. You can't libel a dead man because they aren't alive to have any reputation to protect. Public officials are another category, which are almost libel-proof. You can say pretty much anything you want about Rudy Giuliani, and he's not going to be able to sue you for libel, or at least he's going to have a difficult time in collecting. But really what it boils down to when you're writing the ordinary article is you want to make sure that your facts are right. You want to make sure that if you're relying on human sources as opposed to documents or something else, that you have sources which are reliable sources, preferably ones that you've dealt
Do
with
you have
in
to
the
check
past.
them out with another source?
You don't always have to have a second source. I mean, that's sort of the thing you see in movies like All the President's Men. You don't always have to have a second source. It's always a judgment call by the reporter and the editor. Some publications say for particularly sensitive pieces of information you do. Others have different policies. It depends on the publication, the reporter, or the editor.
Martin, if you win this lawsuit,
Right.
what happens? You get money?
You could. The important thing for me is that there'll be a declaration that this journalist has acted irresponsibly. I think that if you care about the First Amendment, you know, using Ed's description, that this, or my description, he's a wild cannon, that you will stop him from writing about people. He has done this before.
Are you entitled to compensatory damages, money damages, if you find that the newspaper...
You may or may not be here, in this case. You are in libel cases.
Okay.
You may or may not be here, because generally what happens in a libel case is if I libel you and you lose your job, then you can get money for that.
I see.
If I libel you and you have a mental breakdown, then maybe one can recover for that.
I can't work, now I have pain and
But in this
suffering.
particular case, the young girl's in her late 20s. She was a former Yale student. She didn't lose any work as a result of this. In other words, as a result of the rape, she went into rape counseling for a long period of time. But it's hard to say that this particular story in the newspaper cost her any dollars. Did it cost her anguish? Yes. Can she get damages if she can prove a loss to her reputation? Yes. Can she prove a loss to her reputation? Yes. How do you prove it if she's only called Jane Doe?
If you prove that the newspaper, the Daily News, acted in a malicious manner, is it possible to get punitive damages?
It's possible in all cases of libel. There's a legal issue here as to whether someone who is called Jane Doe and has allegedly not had their name blasted all over the place can also get punitive damages. But yes, generally in libel law you can, where something is egregious, get punitive damages.
Now, I know you're a member of a 40-attorney firm. I know you're highly respected in the community,
Thank you.
and you demand hundreds and hundreds of dollars per hour to your paying clients. I mean, how does someone of this nature be able to afford you?
She's not able to afford me. When the woman walked into the office and she told me what had happened to her, I then felt and she could not afford to pay fees, I felt, given who I am, that I had no option but to represent her, recognizing that it would cause problems perhaps with my media clients. I felt that I had a responsibility, given the fact that I understand how the media operates, that I'm a good lawyer in this area, that I had some kind of obligation as a lawyer to this woman.
Now, when you advise your media clients on libel, and how do you advise them to avoid libel?
Well, you do two things. One, if you see that somebody is called a crook or a hoaxer or who has done something perjurious, you check it out. Now, I represented for 8 years. We were tied up with nearly the exact claims in a court in the Midwest where a journalist named Peter Matheson, and my client at that point was Viking Penguin, a publisher, had said of the governor of the state of South Dakota that he was a liar, had filed perjurious affidavits, etc. Now, when the book came to me for libel, I asked to see every single document involved in that criminal case, or whatever it is. In this particular case, the lawyers, let's say for the Daily News, and we know this from the depositions, never contacted the police, never contacted the hospital records, never saw the lab report, never spoke to one single person who was at the scene.
Now, you got to remember here, you, in the case you just described, were dealing with a book. Long lead time, got plenty of time to review documents and all sorts of other sources. lawyers for a daily publication, particularly a tabloid that works on very short
We're talking about
deadlines,
something different. We're talking about a case.
Don't have that
We're
option.
talking about a different case. We're talking about a case where 25 journalists from the Daily News brought to the attention of the Daily News that these articles were inaccurate. We're not talking about story number one.
Did those? You keep
We're not
mentioning
talking-
that.
Just hear me out. Wait just a minute. We're not talking about story number one. We're not talking about story number two. There was a 13-day spread. If I'm working for a publishing company and someone tells me that something is inaccurate, or if I find that something is inaccurate, I do a more intensive check. Here, nothing was done after the Daily News gets this petition. Secondly, the same day that McAlery writes the second article, the Daily News has other reporters covering the story. McAlery's beat is not a police beat. He's not a police reporter.
Although that's what he spends a lot of his time doing, covering those stories.
You had two other reporters, Virginia Breen and David Martin, covering the story. The same day that McAlery's column says no physical evidence of rape, on the same page you have the same people from the Daily News saying the contrary.
Ed, you wanted to respond regarding...
Well, I think you keep bringing up these 25 Daily News reporters who signed a petition. I am positive all 25 of those didn't go out independently and check the story and know for themselves that they couldn't find sources.
What they did is this. They knew who McAlery was in the same way that you said you knew who McAlery was. They saw that the New York Times, the New York Post, the TV reporters, that everybody was covering the story. They saw that everybody was saying the same thing. They saw that the Commissioner of Police basically rejected what McAlery was saying. That's what they saw.
Right. They didn't have any special knowledge. They just had the knowledge that any reader or viewer of media in New York would have.
No. They understood, and they understood that the Commissioner of Police had said that there's physical evidence of rape. McAlery didn't report that. Now that's what they had. They had an awareness. The lab report on the second day says, and there's a magic word called antigen, which is evidence of semen. The newspapers are reporting that that's what the lab report says. If the lab report says antigen, that's evidence of rape. 2 weeks after the lab report says that, and after there's a further lab report on May 10th, he writes another article. What the Daily News reporters recognized is what you recognized, namely that this is an irresponsible journalist. And they wanted to disassociate themselves from it.
I understand that. All I'm trying to get across is that anybody who was watching the media during those 2 or 3 weeks could have made the same judgment based on the same set of facts those 25 Daily News reporters had. Those Daily News reporters don't have any special knowledge about the facts of this case. They just see that McAlery is standing alone, the rest of the media is over here, and they want to be with the rest of the media.
No, no, you're missing the point. The Daily News journalists themselves reported the lab reports. They reported the hospital records. It's not just a question of counting heads. There's documented evidence in a case.
Right. But I'm saying not all 25 of those were reporting that story. That's all.
I'm not sure what you're saying any longer.
Ed Adams, thank you very much for appearing on Law Line. I'm sorry we didn't have more time to continue this conversation. You're from the New York Law Journal, and I again appreciate the efforts of the Law Journal. And Martin Garbus, First Amendment. Martin, you with the firm of Frankfurt, Garbus, Klein, and Seltz. Thank you very much for appearing on Law Line. And as always, this is Alan Schnorman. Thank you for watching Law Line.
You have been watching Lawline with your host, New York trial attorney Alan Schnorman. Mr. Schnorman will be back with you next week at the same time. If you have any questions about this week's program, please write to Lawline, 63 Wall Street, New York, New York, 10005, or call area code 212-432-9111.